regulation from policy to products and compliance and design. Welcome, Brian Williamson.
Thank you. And I'll just make some introductory remarks. I'll invite the panelists up soon. And I will talk for 5 or 10 minutes, setting out some thoughts about what's happening in this area. And then we'll interact with the panelists. And there will be time at the end, maybe 10 minutes for questions as well. Well, I'll introduce each of the panelists. Ollie Bethel, to my left, is Head of Competition and Regulatory Engagement at Google and has been leading on a range of competition-related policy issues, the Digital Market Act in Europe, competition cases, and strategic market status investigations. Next, we have Alexander Waxman, who is a partner at Gunnar Cook, a specialist in UK and EU competition law, with expertise in digital platform regulation, compliance strategy, and behavioural investigations across the tech sector. So a strong competition focus. And then we have Annabelle Gore, who is an academic, a professor of digital economy at the University of Surrey, and a pioneer of platform ecosystem research, and advisor to governments and on platform regulation. So I'll make some introductory comments now, to some extent thoughts of my own. I'll say at the outset that I am more a policy than a product person, but I think the others will be able to bring in the product perspective as well. So I looked at last year's discussion along these lines, and one comment was that it was the kind of age of remorse for regulators. And what that meant was regulators thought that they had got it wrong with social policy. They should have, with platforms, social platforms, that they should have intervened earlier. I'm not sure that's true. I'm not sure they would have known what to do very early on, but that was what they thought. And they had quite a lot of confidence, I think, about what the problems were and what needed to be done. And that is extended into areas including AI. I think a lot has changed in the last year from that kind of age of remorse or confidence about what to do. So what that led to was kind of convergence at the time on an approach to preemptive, what I'd call preemptive regulation, not waiting for competition law, but setting the rules in advance for the market. And you may have heard the term the Brussels effect, which was the idea that if Brussels led, the rest of the world would follow. And that had happened to some extent with data protection. And another term I hear frequently in Brussels is that a desire to do things that are future-proof, which I think is harder than one might think. The future is full of surprises. So regulation of digital markets has grown. Just get a drink. And you'll be, to some extent, familiar with the GDPR, with competition rules. And more recently with the EU AI Act and other initiatives in different regions. However, I think the future comes at you fast. If we were confident about all of that 12 months ago, AI has been around more than a year, but it's much more prominent now, I think. It's partly that it is more capable. It's partly that more people are using it. It's partly that people have noticed an awful lot of money is going into it. So I think it was obvious to people in the field that it was a big deal some time ago. It's become more obvious to politicians and others much more recently. So that's the first thing that's changed. But you've also seen in the last 12 months, perhaps a bit more, a sort of convergence of regulation, a degree of divergence. Most obviously with the US, change of government and change of position. And if I look at the White House action plan on AI, that kind of encapsulated one part of that shift, which is it had a principle of try first. Try AI first. Let's think about whether we need to regulate or how we need to regulate sometime in the future. Whereas Europe is more characterized by what they call the precautionary principle, which is let's regulate before problems arise. That's a huge difference. The UK is probably somewhere in between on that front, maybe a little undecided. But certainly in regulating digital markets for competition, the UK has a framework which I think is more able to adapt. it's more open to the regulator applying that as the market evolves, whereas in the European Union, it's more prescriptive and kind of fixed, harder to adapt. So I think that's an important dimension. I mentioned briefly, because I am an economist, the economics of AI. What we've seen is market entry, quite a lot, actually. There are all sorts of people contending the space, as well as the established players, if you like. It's characterized by capital intensity, which is not the way we thought about digital markets historically. And so there are incremental costs to growth. It costs, inference costs money. And we're used to being able to scale things like social networks at very low incremental cost. So it's different. And some have argued that the network effects may be significantly less than they have been with previous eras. I think that remains to be seen. If people really value personalization, it may be there are network effects in that sense, that you get tied into the AI that knows you, but we shall see. So the economics are just different to what digital markets have been like for the last 2 decades. The other thing I'll mention is that sometimes you have to create regulation to have new markets. And one example in the UK is the Automated Vehicles Act of 2024, which created a framework within which services like Waymo could launch. There's a more general point here, which I don't think has been picked up much, which is a lot of the way we govern safety and other things in society is by recognizing that people have qualifications or credentials. So you can get your driver's license, then you can drive a car. You need a different model if it's AI. It's not the same. And the same with medicine and law. If you have certain credentials, you can do certain things, prescribe a medicine, say. So I think we will have to rework all of that, and we have hardly begun on that front. So that's a huge area, which is not so much about regulating AI, but enabling AI to do things. And I think it also means that AI will not progress economically as fast as some technologists think, because there are a lot of things, even if it was capable of doing them, legally it wouldn't be allowed to do them. That's kind of an interesting area. So I'm generally skeptical about regulation in terms of its harm to innovation, but actually here we need different or new regulation to allow things to happen. Almost finished. A broader policy question is, what outcomes do we want? Do we measure, which I think is important, because that creates a feedback loop to improving things. And how do we adapt to market changes and correct errors? We will make mistakes in any new area, and we need making mistakes, in a sense, is not the worst thing. It's correcting them. And if you watch Europe trying to deal with the AI Act that it's created, it's struggling. It kind of knows it's made a mistake, and it doesn't quite know how to correct that mistake. They don't want to throw the whole thing out, but they kind of know that it's too hard for companies to comply with, or certainly smaller companies. And given regulation, and this is really the theme for today, how do companies, large and small, make product decisions, engineering choices, and design governance systems that can work within the company? So from policy to product, compliance by design, that's our theme for the session. Just check time. Okay. I have a question, which is a kind of general question, which I'd like each of the panelists to have a go at, and I have other questions where we can dive a bit deeper, and it may be that organically different questions will come up as well. So I probably go from work left. The general question is, what are you trying to achieve with regulation? What does compliance involve, and how do we know if it's all working? And you don't have to answer all of those things, but something along those themes.
I'm glad I start. I'm not cool there is out of the way for you. Okay, so where to begin? So I'm Ollie from Google. Thanks for having the opportunity, or giving me the opportunity to speak to you today. I suppose like 3 observations from Google's perspective when we think about particularly competition regulation and how that can work well. And one of my observations, having worked through a raft of these different types of regulations over the years, I've been at Google for about 16 years, is that the hardest thing you can do when thinking about new regulation or engaging with new regulation is to define the problem statement up front, to have a sense of or there's this exciting thing happening in AI. There's a lot of people using a new service. That seems exciting. I'm reading about it in the FT and the Economist. We ought to do something there. But what is the thing, and why do we need to do it? I think that exercise is often something that we rush past and then later try and sort of retrofit a load of problems into a solution that we've already built. And so I think good competition regulation, at least, has a very clear and targeted sense of what it's trying to achieve. The second thing that I think is important is to not treat that exercise as necessarily monocausal, to look at an observed problem in a market and to naturally assume that competition law or competition regulation is the right tool to address that. It may be in some circumstances, but it may not. And increasingly, when you look outside of the sort of regulatory, or at least the competition regulatory bubble, and observe the kinds of problems that people are talking about in general discourse, we're talking about infrastructure, we're talking about energy, we're talking about societal concerns with the output of some of these models. That tends to be the type of things that people are focusing on. And what is the part that competition can play? It's a complement to other forms of regulation, I think, is often a very important thing to consider. In the course of the Digital Markets Act, it always struck me as a very broad piece of legislation. There's around 22 rules in the Digital Markets Act. It attaches to a raft of so-called core platform services. And what that has meant is that the aperture for regulatory dialogue between us and the other gatekeepers and the European Commission is very broad. We spend a lot of time talking about a lot of issues. I'm pretty sure that in that set, there are issues that are not so important to high priority policy issues for consumers or businesses in the European Union. Saying there's just some initial observations. And then how would you think about whether a piece of regulation is operating well? Well, I think you can start at what's it doing for price, what's it doing for quality. Those are obviously familiar metrics for competition practitioners. But then I would posit that regulation, competition regulation in particular, ought to look at a broader set of hallmarks of innovation and competition. And when you look at the area that we've been focusing on in these discussions thus far today, and in plenty of other events like this, the speed with which products are being brought to market, the volume of citation of patents and trademarks that are being brought to market in this space, the amount of sort of landmark and consequential developments we're seeing, particularly in the scientific area, a whole raft of hallmarks of competition that you would say tend to suggest that things are operating quite well. Now, that's not to say that there aren't necessarily places where you might want to make a targeted adjustment, ensure that things are operating as quickly as they could do. But plenty of the hallmarks seem to be indicative of competition working quite well in some of these spaces. So I think that perhaps militates in favor of being very realistic about the causes of the problems that we see out there and the limited impact perhaps of competition law to address them.
Yeah, I think I'd actually like to do what all good panelists do, which is not answer the question I've been asked and answer the question I prefer to have been asked. So I think when I'd start with is what regulation should not be trying to achieve. And hopefully this is obvious, but I think what regulation should not be trying to achieve is applying preconceived models of how digital markets work and engineering markets to match regulatory preferences. So I'll give an example to illustrate. So maybe I could take everyone back to 2023, what I would term sort of peak hubris, which was when regulators around the world said, we know how digital markets work. They're all characterized by barriers to entry, network effects, personalization, lock-in. This leads to a series of incumbents dominating each of their own individual areas of specialist expertise. And we see AI coming along, which is a digital market, and so we assume exactly the same thing will happen. And I'm going to pick on the CMA purely because they were the ones brave enough to write a report about foundation models at the time. And there is a passage in their report which has not aged well, which said that if we look at the companies that have achieved strong incumbency positions in important digital markets today, they have all of the components that they need to dominate the AI era. And there were very nice flashy infographics showing Apple and Google and Meta and Amazon and Microsoft at all different points of the tech stack and saying they have everything they need. They have the data, they have the compute, and therefore AI markets will mature just as other ones have. And that means we need to have intervention in order to deal with that. That update report came out in April 2024. At the same time, or around that time, the CMA launched an investigation into Microsoft's deal with Inflection, which found that ChatGPT had a market share of 60 to 70%, and all of the GAFAM firms were nowhere to be seen. About a month later, Grok launched its Model 1.5, which was found, having only been developed a few months earlier, to be as capable as ChatGPT 4. And since then, the market shares have only continued to move away from what the CMA would have called the incumbency firms. So I think what regulators should not be trying to do is trying to assume the knowledge of how markets will work and engineer outcomes to fit. I think what regulation can do more successfully is to be a little more modest in its goals, and instead to focus on things like kind of basic levels of transparency. Do companies accurately report how their products work? Are companies making appropriate levels of disclosure to ensure transparency while avoiding disclosing trade secrets? But fundamentally having what I think is quite a brave posture for regulators, which is to say in some markets, it just doesn't make sense for us to intervene with the full force of law, even if certain parties might like us to do so. So I think it's that sort of level of modesty that regulators should be trying to achieve.
Okay. Annabelle?
Yes, thank you. Very interesting remarks. I don't think I agree with you, however. But it's nice to hear people say that regulators should be modest. Oh, if they could just know the police, it would be better off. Not so sure. Spirit of the first couple of comments about, you know, and soft power, get power. So quantities of spot. Quantities would be high and higher that the it was working. Obviously, storage services for free, tries to exactly subsidize our activities. It's not that simple to define what is it. We have to look for the who done it, extra price to pay. So when we looked at digital markets, what we've seen is a more complex. Is this working? Thank you so much. More complex understanding of what we talk about when we talk about corporate power. And for those biggest big tech platforms, it's not just an ability to price. It's not just about, not perhaps delivering the privacy that people should be entitled to. It's not just guiding you and structuring your choices in a way that you might not be aware of. It might not just be presenting in front of your eyes or your kids' eyes or vulnerable people's eyes some information that may be, detrimental to their development, to their well-being, or to their ability to function in a democracy. And so obviously, this is a messy problem. And it's very comforting to say, well, look, it doesn't quite fit within the, economic, view. So, there are people who think if we can only solve the competition part of it, everything else is going to get sorted. As soon as we're going to have markets that become contestable, then all the bad behaviors that dominant firms can get away with are going to fall by the wayside because consumers are going to vote with their feet and they're going to go towards others. That's possible, but we're all living in a huge experiment that is happening in real time, and that is causing damage in real time as well. So whatever theories people have about what should happen are just theories. We are living the experiment. We are in the matrix. And I think we all should have a little more humility, not just regulators, but also companies and also citizens. But we can also call a cat and recognize when the business models lead to divergent incentives between what's good for some users, maybe on one side of the platform, maybe those who don't pay that much, and others. And, divergent incentives and abuse of power are nothing new. They didn't wait for digital to happen, okay? Digital put that on steroid. So to go back to the question of which regulation, I would agree with you. In Europe, there is a ridiculous amount of regulation. It's too much. Regulation about this, regulation about that, regulation about this, regulation about that. Very difficult to comply to. I think the so-called Brussels effect is a bit of wishful thinking. Let's tap ourselves in the back. We are so important. But we have a new paper which is going to come out in a couple of weeks in Management and Business Review with Mike Jacobidis and two colleagues from BCG, Nicholas Lang and David Zuluaga Martinez, where we're looking at the AI regulation and we're looking at from an angle of the political economy and the geopolitics of AI regulation. And we come with one, and there's one important idea in this paper, which is that depending on whether you as a country or a region project yourself in a world where you're going to be mainly a consumer of AI, or you project yourself in a scenario where you're going to be mostly a producer of AI, well, the kind of regulation you want is very, very different. And so what we see is that Europe is putting out regulation that is protecting users or aiming to protect users. The US and China, to some extent, have a very different view. They want regulations that allow them to continue to produce AI. And so I think that in order to answer the question of what are we regulating for, there needs to be this preamble question, which is, who are you? And what role do you want to play in AI? That of a consumer or that of a producer? And I think if we don't put that question out there, we risk sort of talking past each other. I will stop here for my first remark.
Thank you. Well, there's a few interesting things here. Certainly a question about whether we've had too much hubris in the past, both regulators and potentially everybody. I think it is everybody, actually. We just need to accept that the future will involve surprises. This point about problem definition, which is recurring, and whether it is all a competition problem, and I think the answer is no. There will be problems that arise that wouldn't be fixed by more competition. They're just different. And this point about consumers versus producers, of course, every country has consumers and should be concerned about them, but some are more focused on enabling the production of AI, focused on barriers to generating more electricity and so on. So that's correct. I'll dive in with some more individual questions, and I'll start with Ollie again. What characteristics would make for an effective tech regulator? Capable of kind of having the product level discussion that would be productive, and what does a good dialogue look like? And then the counterpart of that, from the company side, what kind of regulatory engagement is helpful? What can slow down product teams without improving outcomes? So, yeah.
So, what makes for a good regulator? Confidence and courage, I would say, and I'll explain a little bit more about what I mean. I think that I take Annabelle's points very well. I think part of if you're engaging with regulators, as it is inevitable that a company of our size has to, you have to engage in a way that presumes that if the process has operated fairly and reasonably on the evidence, then you may be told to do things that you would prefer not to do. That's a part of the model of engagement. It's a process that's led by democratically elected decision makers, and you have to respect and engage on those terms. I think as you're engaging, what makes the process faster, cheaper, more measurable is a number of things that I think, as I say, fall under this head of confidence and courage. Being very clear about what we're trying to achieve together. I think one of the big challenges in some of the legislation that we've worked with recently has been either one end of the spectrum, very prescriptive types of solution that perhaps would have solved the problem of 6 months ago or when the legislator was drafting, but clearly aren't future-proof now, and we nevertheless have to comply with them. I think the DMA has a couple of examples of provisions like that, probably too specific. And then at the other end of the spectrum, you have very, very broad sort of discretionary rules. Thou shalt not self-preference. I mean, you think of the nature of the integrations that a lot of the larger companies and to be frank, mid and smaller size platforms who are sort of at an earlier stage in that process are looking ahead to a world where as a platform technology, there will be all sorts of integrations. So how on earth do you think about how to properly comply with a broad rule of self-preferencing? So having a very clear, future-proof, so sufficiently malleable, but not so vague and opaque so that you don't know where you're trying to head to, that notion upfront is very, very helpful. A willingness to engage at a technical level as quickly as possible with the technology firms. I cannot tell you how helpful that is. I pride myself on my own skills as a lawyer, and I've got plenty of great lobbyists, but that part of the conversation doesn't really have much upside in the engagement with the regulator who's trying to understand the underlying technologies, who might want to brainstorm with you particular types of solutions. So getting technical as quickly as possible. I think it's very encouraging in the UK, see the amount of investment that there's been in having sort of data scientists, UX designers, those kinds of people in the discussions with technology firms is very, very helpful. A willingness to adopt an innovator's mindset, right? Even though you're sitting in a regulator doesn't mean that you can't take that sort of mindset. And I think that means engaging with us, being prepared to experiment, being prepared to iterate on solutions. We will not get it right. Perhaps this wasn't the problem that we should have been addressing. As plenty of you here will know, as innovators and product designers, version 3, version 4, version 5, perhaps that's where you want to get to. So willingness to engage on those terms, to be courageous about turning down experiments when we haven't achieved the type of outcome that we want to achieve. I think those are all really important components in the day-to-day with the regulators that we work with.
Thank you. Alexander, how should the rules evolve when potential harm is unclear and market structures are in a state of flux? You might also want to comment on this kind of point about, that Ollie made about regulators being bold and courageous. Is that consistent with, how do you deal with the overconfidence when we're too predictive about the future or too confident that old models still apply as well?
Yeah, I think the short answer is, how should rules evolve when the harms aren't clear? It depends partly on the regime you're dealing with. So if you have a regime like the Digital Markets Act, where the rules are hard-coded into legislation, it is very difficult to evolve them. Right, there are certain steps regulators can take, but that is difficult, and you end up with legislation that can sometimes be brittle. And you have to, of course, look for broader legal principles to try and ensure that laws are interpreted in an optimal way, but there are limits to that exercise. I think in other regimes, such as the CMA's digital powers, which does give it rulemaking ability, it has the ability to be more interventionist than the DMA, but it also has the ability to be less interventionist. And if you are dealing with a situation where the harms are unclear and unproven and unsubstantiated, my view is that the rules should not be getting made at that stage. The rules should be delayed until there is a harm that they can anchor on. And the reason that's really important is not simply because of a philosophical position that intervention is presumptively bad. The reason it's important is because unless you have a harm that you are trying to address and that you can concretely argue about, rulemaking is replaced by a value-free void into which pure lobbying and rent-seeking step. You'll simply have different parties arguing and trying to push a regulator to allocate rents in the way that best suits their businesses. Now, I think that actually there are very important safeguards that have been built into the UK legislation against that happening. So, for example, it is kind of trite among regulatory lawyers to just throw their hands up and say, look what broad powers the CMA has, there's nothing that can be done about it. But actually in the legislation, there is a set of statutory objectives that the CMA has to show that companies are deficient against when deciding to regulate. So, for example, that the terms in which they trade are not fair. There is a requirement for regulators to have particular regard to the benefits of consumers that may be enhanced or lost through regulation. There is an explicit principle of proportionality and a recognition in the legislative materials that intervention may engage companies' property rights and ECHR rights. And there is also a principle that if companies' conduct might theoretically infringe some of the rules that are imposed, it can nevertheless be justified by countervailing benefits. And so I think actually I'm not aware of any legislator who has said there doesn't need to be harm. We just go ahead and charge ahead with rules to try and remake markets in the way that we think they should be made. But I think it's really important that regulators do anchor on this principle that rules should evolve to fit the harms that they're seeing and that are substantiated, and not simply to make rules because of a preference about how a market should look.
Thank you. To Annabelle, I think my question is kind of broadly around bringing a ecosystem perspective to this. And so how do you think about compliance, given that if you apply a rule in one place, that'll kind of cascade through a system? The ecosystem may be to some extent integrated by a platform, Apple, for example, to control a lot of aspects of that ecosystem, or it may be voluntary, but according to APIs or something like that. So how do we think about the way regulation is applied and then works itself through an ecosystem? And I suppose there's a broader question about how should regulators view ecosystems, because they tend to like to take things apart, have competition in every aspect. But does that involve any trade-offs in terms of innovation? Do you sometimes need an ecosystem to get innovation?
Brian, it's a great question. And this is a very active area of research, and that is beginning to have some impact on regulators. So, for example, the Brazilian Competition Authority recently, in a decision about Apple, used literally the notion of ecosystem theory of harms. So going back to the point you were just making about with which I completely agree, that rules should not exist in a vacuum or just express value statements, but be on the basis on identified harms. Actually, when I was an expert in a working group called the it was at the European Commission. It was the first observatory of the online platform economy. And some of the work we did was a precursor to the DMA. Obviously, there were many other people who were involved. But what we did for months was to try to come up with a catalog of practices and try to evaluate whether they were problematic and problematic for who. So at least in this example, it was very much harms driven and with an open mind. Because obviously, you could consider something as harmful, but someone else could say, actually, it's not harmful at all. So the very notion of harm also sometimes depends on, who is examining the harm. Just like value is in the eye of a beholder, it could be hard sometimes to have everybody agree that a particular practice is harmful. But be that as it may, to go back to the question of ecosystems. So in the digital economy today, a lot of products and services, most of them are really connected to each other. We've got seamless integration via, cables, protocols, software, and data. Okay. And the value is created often by multiple actors that generate some data that gets processed and exploited in other parts of the network. Actually, one of the paradoxes of the digital economy is that, in the emergence of these so-called platform firms, is that even if the process of value creation is very distributed across these ecosystems, the value capture is very, very centralized. That is, the ability to generate profit is very centralized among nodes of those ecosystems. Therefore, the traditional view of that says that you only need to look at one particular market, and one market being defined as, if you're in the market, you are just all competitors to each other, or products are substitute to each other. And that's all you need to know in order to understand what matters in terms of the degree of competition or the health of this market. That simply doesn't stand when the strategies that companies have do not operate within vertical slices or these silos. The strategies are about creating a value that spans across multiple sectors or multiple markets. And decisions both about technological decisions about interfaces, what kind of data do we allow to go from one sector to another, from one group of users to another or not, as well as decisions about pricing. Which part of this value proposition are we going to give away for free? Which part are we going to charge for? All these decisions are taken together. Okay. And that's why you have sometimes companies that seem to compete with each other on something. For example, you could say that Google and Facebook or Meta are competing for the attention of advertisers. You see that they're doing it in very, very different ways, with very different things that they sell and things that they make money of and other things that they give away. So it is necessary to consider an ecosystem, that is a constellation of companies that are going to work together to produce value, in order to then ask the questions about regulation and so forth. So just to finish on this, one tough nut to crack is to say, how do we define an ecosystem theory of harm? Do we need to mobilize this notion of ecosystem to describe a certain kind of harm that perhaps could not have been described, by other concepts, such as foreclosure or preventing a company to enter and things like that? It turns out, and I don't have the time to go into detail, yes, there is really a need to expand the regulators' tools so that it matches the strategic toolkit that companies have when they enter, price, and design product and services in these interconnected markets.
Thank you. I'll start with kind of set of related questions for Ollie again. Well, the first one is kind of a more practical thing. How do you translate regulation and regulatory language into engineering decisions as a practical matter? And kind of related to that, and something that I think is more prominent now, and kind of comes in three forms. When is it better to launch a product globally that complies with all regulation versus launching somewhat different products in different markets, which we've seen happening recently with AI and other services, where they're not, a new version is not necessarily released in all markets at the same time or with the same features. Should you just, if you're a startup in particular, should you try a easier jurisdiction first to test the market? And I certainly, one I'm familiar with was Zipline, who launched in Rwanda first, because they could get the kind of regulation they needed for the drone blood delivery system. And then once you've proven it there, maybe you can have a better conversation with regulators elsewhere. And then the other question is related to size. If you're small but scaling, some regulation kind of comes in with thresholds. How do you think about that? So it's kind of bringing it back to, if you're a company and you're looking at the regulatory landscape, how do you deal with that? What do you do in the product space?
Okay. So maybe on the how do we operationalize the regulations that we receive at Google? As Annabelle has said, I think it's very, very fair to say that in some areas we're across competition and non-competition issues. There are thousands of rules that you have to bear in mind for a particular launch, and that has a certain amount of demands. For the product launch decisions that are taken by the teams that I work with at Google, I suppose it becomes sort of beautifully, elegantly simple. It's a question of, am I going to launch it never, later, or now? Right? That's kind of that's the call. And when the sort of hapless competition law arrives in that room, where the same people have been told probably two things that same day. First of all, OpenAI launched this yesterday, and secondly, we're having lots of conversations with the government in this particular country, and some people there are telling us to be as productive and competitive as we possibly can right now, because that really matters to this particular government. So those are a couple of priors when someone like me arrives in that room. And then how do you operationalize what you bring in your roll along suitcase with you? Well, first of all, is that suitcase carrying like a heavy tome of abstract terms? If that's the case, then probably tracking towards much later or never. Right? I think that's a natural consequence of that. The speed with which our launch decisions have to be taken does not give you infinite time and capacity to sit with me and pass through complicated tomes of legislation. So is the law itself, is the text clear? How many laws are there? Can we understand quickly what we need to do? If it's not the case, and oftentimes it can't be the case, because as colleagues here have said, also you need to accommodate future product designs. Not every piece of legislation can perfectly envisage what is ahead of it. So there will be times when there's some abstract text that you have to deal with. Then it comes down to the nature of the relationship with the regulator and the agency that you're dealing with in a particular moment. Can I quickly talk to them? Can I quickly bring my engineering lead, my product design lead to that agency to talk about what we're doing, to try and understand whether there's a way to track through the rules and regulations as they apply to this particular launch? That's tremendously helpful. Varies quite significantly between agencies. It is a function of courage and confidence, but I think where the laws are not clear, your ability to do that allows you to track much more towards the now, or if not now, then soon, rather than the never or much later. So that's a little bit about how we sort of think about operationalizing these things. Truth be told, there are some areas of law currently where we already know, without going into a room, that the answer will be much, much later. It is very complicated to launch in this particular jurisdiction. I do think there is a challenge in the European Union right now. I do think there is a patchwork of legislation, and I see it. I see product decisions leading to delay. AI mode in search was something that was launched much sooner in the UK than the rest of Europe. It's still not launched in France, and that is a function to some extent of the regulatory framework in which we're operating. As to your second question about the when does it make sense to go global or regional or by country, perhaps it's related to my first answer there. I think in a perfect world, you would launch globally, collect all of the test data, and then iterate as quickly as possible, so all consumers and businesses have the opportunity to react to the launch, which may not work in its first iteration, but it's good to learn that as quickly as possible. In practice, that rarely happens. In practice, what tends to happen is that we're looking to regions and countries where we have the kind of relationship that I've described, at least in the competition framing, where we're able to say, listen, we're not entirely sure what this law requires. We do have a good relationship with this regulator. We will be able to talk with them. They are not going to immediately fine you billions of euros if we get it wrong in the first month or two. We'll have an opportunity to iterate, and we'll work with this regulator to move at pace to give you the feedback that you need. And I think you'd be surprised by the appetite within Google to have those kinds of conversations, to travel physically to talk to people about the nature of the launches to ensure that they can launch at speed. The third part of the question, sorry.
Scale.
Guys, we only have about, we're about 10 minutes or 5 minutes over, so you got 5 more minutes.
Yeah, I just very, very quickly. The larger your scale, the more necessarily the more regulation you have to manage. That's a consequence of success. I think there's just a question of how much of it needs to come with that scale.
One quick comment I'll make based on what you've said, which I think is interesting to an economist. It was mentioned earlier that, from a competition perspective, you're interested in prices and quantities, but you've mentioned products that don't launch in a particular market, or at least are delayed. And so there's an interesting question about what is the cost of just not having something. It's not having it and having it a bit cheaper or a bit more expensive. It just doesn't exist. And that can be a much larger economic cost, and we probably don't think enough about that. I'll move on to Alexandra. We have to keep it short now, but the question was about legal risks when companies are complying, and in particular when they're looking at different jurisdictions. But I think a related question that we won't have time to get into, I suspect, is whether there are other ways that other things that are coming into play with compliance, and particularly might be relevant to smaller companies. Do platforms, in a sense, provide compliance for smaller players? And I have this kind of notion of compliance as a service. And insurers are also talking about AI in a way which would almost be regulating the market, because they would say, we can insure you against liability, but you have to do these things. So I'm introducing parties other than the regulators as regulatory agents. Say whatever you
maybe just one quick one. I think the more insurance you need against inadvertent breaches of the law, the more problematic that law probably is. Because in a perfect world, you should have laws that are clear, justiciable, everyone knows what they do, and that is the contribution that the rule of law can make, I think, to economies at large, but digital economies in particular, where the law has to be able to accommodate new products and new entry. And I think my plea coming away from all of this to regulators would be a little dumber and a little simpler. Focus on the things that really matter: price, quantity, product availability. And I think if regulators focus on that, then they're not going to go far wrong.
Annabelle, I think I'll kind of leave it up to you, but one question I had, you mentioned this kind of ecosystem perspective. If you want to answer that question, is how would you actually go about getting regulators to think that way?
To tie actually the points of my co-panelist here, when we're talking about compliance of, say, big tech platform firms, as well as compliance of ecosystem members, which may be, a third-party seller on Amazon Marketplace, for example, it's very important to realize that big tech platform companies don't just sell products, right? So, for example, one of the big role of Amazon with Amazon Marketplace is to govern the compliance of millions of vendors globally. So they play a role of a government, if you wish. And the question of, can they keep the platform safe from fraud? Can they regulate their platform so that the sellers don't cheat, don't sell dangerous products, don't put fake reviews, don't attack other people, other sellers, etc., is really important. And we have a new paper that just came out in Research Policy that showed that third-party sellers, some of them transgress, so they don't comply, they cheat. And some of them are good boys and girls, they do what's expected, and some of them are somewhere in the middle. That's the starting point. But then we've interviewed many, many, many of them, and we've looked at thousands of pages of reports. What's really interesting is that when the third-party sellers, i.e. the ecosystem members, observe the behavior of the central actor here, which is Amazon, and they observe them not doing such a great job at governing the platform, apparently punishing some people for some transgression, but not other people for the same transgression. So a sort of developing a mistrust of the platform authority as a regulator, because they seem to police in a very ad hoc manner the compliance of their own rules. That has a nefarious effect on future compliance of the ecosystem members. So because they mistrust the central authority, what happens is a social contagion of misconduct. So it's like a ripple effect, a cascading effect of misconduct that happens. And we shouldn't overlook the role of those central actors in the way they behave and they govern their own ecosystems, to influence positively or negatively, millions of ecosystem members, which, there's no reason to assume that they are all honest or they're all cheating, but they certainly can look at each other's behaviors. And many of the ones we interviewed said, well, everybody's cheating, therefore, in order to survive, you have to cheat. And we don't want to be in economies, whether mediated by platforms or otherwise, where there is a sense of, without corruption, you can't survive.
Thank you. I think with the remaining time, we want to take audience questions.
Any questions?
Okay, Annabella, I'll be very short. I really love your example about ecosystems of arms. I was curious to know about how you measure times and degrees that the arm can be caused at. An example, in the US, the financial market is far more liberal, and so everybody can invest in anything. In the UK and Europe, we are far more conservative with preventing people who are not high net worth and sophisticated investors to invest in private assets like startups. And so that has massive consequences. There is arms in both sides because it's never perfect. So for me, the arms, the way you describe it, the arms there is always arms. There's always consequences. So I'm super curious to know how you think about the degree of the arms, and then over what period of time do we consider the impact?
I mean, I don't have the answer to this, right? I mean, my colleagues probably have more views on that. I was just saying that, exactly agreeing with you. What could look harmful to one person could look, not harmful to another person. That's where regulation has to be very clear. It used to be that it's very clear what harm means in terms of, competition going bad, foreclosure, preventing entrance, maintaining a high price over. These would be recognizable harms. And I think there is still work to do today to have a consensus on what do constitute harms. Because what we have are very high level, like Oli was saying, very high level things like, online harms, cyberbullying, but it can be very hard to operationalize what they are. But that's definitely, I think people are aware of that, and there's progress to be done. But my colleagues.
Shall we do the break, or do you want to do any more questions? One more question. One more. They don't need a break. Do you need a break?
Just guys, sorry for it's for Oliver, because he's from Google, and it's about impact of quantum computing. I have Google has been in news recently, like they have come up with breakthroughs in quantum computing, and they are like leading in that sector versus any other. Like they might not have any advantage, early advantage in terms of AI, because ChatGPT founder OpenAI were leading it, and now so I wanted to understand how the quantum computing will impact the AI implementation, right from the policy development to the final product. Do you have any words on that, please?
In the remaining seconds of the thread, look, I would say I think it's a fascinating question. I think it just very quickly to tie it back to some of Animal's remarks. We think about the ecosystem. I think there are many different dimensions, and one of the ways you can think about the ecosystem is across the AI stack. Where are these innovations taking place? Super interesting discourse. The CMA has done some work in this area. Other regulators have done some market studies. Super interesting. Where are the potential bottlenecks? What's the impact of innovation in one level of the stack flowing through? I will say this. I think quantum computing. We've had a bunch of breakthrough discoveries at Google recently. We have 5 Nobel laureates at Google now. I think that's a good thing for a technology company. It means we're moving forward quickly, bringing innovations to the market. Generally, 12,000 PhDs at Google, by the way. So there's a lot of work happening there, still very much at the R&D phase. So I think to be able to draw a direct causal link to what that will mean for chipsets, inferences, and the flow down, the trickle down effects is a bit TBD. I will close on this. I do think that when you look sort of slightly at other parts in the stack, particularly compute, infrastructure, chip capacity, it seems to me that's an interesting area to be thinking about as competition regulators. I don't see a lot of discussion there, some sort of the beginnings of conversations, a bunch of very interesting deals being struck in the space. So some questions there as to where the potential bottlenecks exist and what should we be thinking about in terms of policy developments to address those. Quantum, a bit more TBD, but thank you very much. It's a fascinating question. Thank you.
I think at this point, thank the panelists, and then I think we're going to be having a break.